The lawyer is reading the will out loud. Your mother-in-law is already standing. She stood up before the paragraph was finished, before the words primary residence had cleared the room, before the sentence ended. She stood up, and the chair scraped back on the hardwood, and the lawyer paused, and nobody said anything for 4 seconds. And in those 4 seconds, you understood that the thing you thought was grief was about to become something else entirely. You are 41 years old. Your husband Marcus died 11 days ago. He was 44. He went to work on a Tuesday and collapsed in the parking garage at 2:17 in the afternoon. Cardiac arrest. No warning, no history. His heart just stopped in a parking garage in downtown Columbus, Ohio, and by the time the paramedics reached him, he had been on the ground for 6 minutes, and 6 minutes was 4 minutes too long. You have been married for 9 years. You have a daughter named Claire. She is 7. She is at your neighbor Deborah's house right now, because you thought bringing a 7-year-old to a will reading was too much. You did not know that what you were about to hear would also be too much. Before any of this, your life made sense. You and Marcus bought the house in Clintonville 8 years ago. 3 bedrooms, a yard, a street where kids rode bikes in the summer and you could hear it from the kitchen. You put $47,000 down. You painted the bedroom yourselves, badly, and then laughed about it for 2 years before you finally hired someone to fix it. The mortgage was $1,640 a month. Marcus made $94,000 a year as a project manager at a civil engineering firm. You worked part-time as a dental hygienist, 3 days a week, $34,000 a year, because Claire needed someone home when school ended and the math worked that way. You had joint accounts, joint everything. You had updated the beneficiary paperwork 3 years ago after Claire was born, because Marcus had read an article about why that mattered. And Marcus was the kind of person who read those articles and then acted on them. You had a will. Simple. Everything to the spouse. Then to Claire. It was done at a notary in a strip mall on Henderson Road. It cost $250. You have the document in the fireproof lockbox in the closet. You knew his parents, Richard and Sandra, didn't love that. They had never said it directly. They were not the kind of people who said things directly. But when Marcus's father retired and they moved from Cincinnati to a condo 10 minutes away, you could feel the pressure of their proximity. Sunday dinners. Opinions about how you raised Claire. A comment from Sandra once about the house, that it had good bones, delivered in a tone that made clear she thought the bones belonged to a structure she had some claim over. You filed that comment and moved on, because Marcus was alive and the house was yours and that was the end of it. Then it wasn't. The will reading is in the offices of a probate attorney named Feldman, who Marcus's parents retained 2 days after he died. You didn't know they had retained anyone. You found out when the letter arrived at the house, your house, informing you that you were invited to attend a formal reading of the last will and testament of Marcus David Reeves. You didn't know there was a second will? Marcus's parents produced a document dated 14 months ago. It was signed in front of a notary. It was witnessed. Under the laws of the state of Ohio, it was legally valid. And under its terms, the primary residence, the house on Britten Road, the house with the bad paint job that you had finally fixed, the house where Claire's height was marked on the kitchen door frame in pencil, starting when she was 3, was to be transferred, in the event of Marcus's death, to his estate, to be administered by Richard and Sandra Reeves as co-executors. You didn't know about this document. You had never seen it. The question of whether Marcus knew about it, whether he had signed it voluntarily, what he had been told it said, whether he understood what it did, is a question that the living cannot answer for the dead. What you know is that your name is not on the deed. You had talked about adding it. Marcus had meant to. It was on the list, the same list that had fixed the garage door and called the pediatrician about Claire's allergy referral, the list that never fully cleared. The house is not in your name. The newer will is the operative document, and under its terms, you have 60 days to vacate. The lawyer explains this in a flat procedural voice that suggests he has explained it before. He explains that you retain rights to your personal property. He explains that the joint bank accounts are not affected. He explains several things, all of which are technically true, and none of which reach you because you are sitting in a chair looking at your mother-in-law's hand on the document, and the only thing you can think is that Marcus's height is still on that door frame. You didn't know yet that what happened in that room was only the beginning of what had already been decided. The case reference number on the probate filing is 2024 PR 7841. You'll come back to that. You call a probate attorney on the drive home. Not Feldman, a different one. You sit in the parking lot of the Kroger on High Street and call the number a friend from the dental office gave you. You get a voicemail. You leave a message. Your voice is steady, which surprises you. The attorney calls back the next morning. Her name is Reyes. She listens to you describe the situation. She asks for copies of both wills, the deed, the probate filing number, and your marriage certificate. You scan everything and email it that afternoon. She calls back 48 hours later. She tells you that Ohio probate law recognizes the most recently executed valid will as controlling. The 2024 document supersedes the one you made together. She tells you that the fact that you were unaware of the document is relevant to a potential challenge, but that challenging a properly executed will on the grounds of the surviving spouse's ignorance is difficult. She tells you that a challenge would require demonstrating undue influence, lack of capacity, or fraud, and that the bar for each of those is high. She tells you her retainer is $3,500. You ask how long a challenge takes. She says 6 to 18 months, depending on whether the estate contests the challenge. You ask what happens to the 60-day clock while a challenge is pending. She pauses. She says the clock continues unless a court orders a stay. Getting a stay requires a filing. The filing costs $800 in court fees alone before her time. You do the math sitting at your kitchen table. The table that is no longer in your house, technically, except that it is, because you are sitting at it. $3,500 retainer, $800 in court fees, approximately $300 to $400 per hour for ongoing litigation. Your savings account has $22,000. Marcus had a $150,000 life insurance policy. The claim is filed. The insurer says processing takes 8 to 12 weeks. 8 to 12 weeks. 60 days is approximately 9 weeks. The insurance check will not arrive before the 60-day clock runs out. And even when it does arrive, if you spend it on a legal challenge that takes 18 months to resolve and lose, you will have paid a lawyer with money that was supposed to be how Claire makes it through the next year. You write all of this down on a yellow legal pad. You look at the numbers. The numbers tell you something that no one in that lawyer's office had the decency to say plainly. You ask Reyes one more question. You ask what your actual rights to the property are, given that you are a surviving spouse who has lived there for 8 years. She tells you that Ohio does not have automatic community property protections for the primary residence in the absence of joint titling. She tells you that spousal elective share may entitle you to a percentage of the estate, 1/3, in Ohio, but that the house being transferred directly under the will complicates the calculation of what constitutes the gross estate for those purposes. She tells you this in language that sounds like a door closing politely. You tell her you'll be in touch. You hang up. You sit at the table for a long time. You call your mother, then your sister, then Deborah from next door, who comes over and sits with you on the couch, and you talk about the numbers until Deborah suggests, very carefully, that maybe it would help to talk to the county legal aid office, because they handle estate matters sometimes and the consultation is free. You go the next week. The attorney there is young and thorough. He explains the same things Ray has explained, but slower, and with a whiteboard. He draws the timeline. He draws the probate filing. He draws the 60-day clock. He draws the options. The drawing does not change the math. He tells you that cases where a subsequent will transfers the primary residence against the surviving spouse's expectation are, he pauses and chooses his words carefully, not uncommon. He does not say what that means about the people who filed them. He doesn't have to. You ask if there is any way to slow the clock. He says that a hardship filing might extend the vacate deadline by 30 additional days if you can demonstrate dependent minor children and insufficient alternative housing. Claire is 7. That qualifies. The extension would cost $400 in filing fees. 30 days. 90 days total if the extension is granted. You file for the extension. You pay the $400 from the joint account. The extension is granted. You have 90 days. The case number is 2024 PR 7841. The estate's attorneys, Sandra and Richard's attorneys now formally, file a response within 10 days, acknowledging the extension, and noting they intend to enforce the vacate order at day 90. Their attorney's name is on the letterhead. You add it to the folder. You thought the hardship extension would feel like a victory? It didn't. It felt like being handed a slightly longer rope. 3 weeks after the will reading, you are sitting in the parking lot of a storage unit facility on Morse Road. You are here because you have started doing the thing you did not want to do, which is calculate what fits in an apartment. You have a spreadsheet open on your phone. A 2-bedroom apartment in Clintonville, close enough for Claire to stay at the same school, runs $1,650 to $1,900 a month. You make $34,000 a year working 3 days a week. That is approximately $2,830 a month before taxes. After taxes and health insurance, which you now carry alone, because the dental office's family plan was running under Marcus, and you are now in the middle of a COBRA paperwork process, your take-home is approximately $2,140 a month. $1,900 for rent, $240 left. The storage unit costs $89 a month. You are trying to figure out which furniture you can sell and which furniture Claire needs to not feel like the world has been stripped down to its studs. You keep Claire's bed, you keep the kitchen table, you let go of the couch and list it online and sell it within 2 days to a college student who pays cash and doesn't ask why you're selling it. You thought letting go of the couch would be the worst part. It wasn't. The worst part is when Claire asks, 4 weeks in, why Grandma and Grandpa are going to live in your house. You don't know what to tell her. You tell her it's complicated. She is 7, which means she understands more than she shows, and she nods in a way that tells you she is going to hold this question somewhere and wait. Your mother-in-law Sandra calls once, during this period. She calls to remind you that the piano in the living room was purchased by Marcus's parents as a gift in 2019, and therefore is technically not your property, and they will be coordinating its pickup. The piano is something Claire plays. She has been playing since she was 5. The teacher comes on Thursday afternoons. You tell Sandra you'll handle it. You hang up and sit on the kitchen floor for approximately 20 minutes. Then you get up because Claire gets out of school at 3:15 and you are the one who picks her up. By month 3, the question was not how to fix it. The question was what was left. You are in a 2-bedroom apartment on Oakland Park Avenue. The walls are white. The floors are wood laminate. There is no yard. There is a parking lot visible from the kitchen window. Claire's height is not on the doorframe because the doorframe is not yours. You are working 4 days a week now, not 3. The practice gave you the extra day. They were kind about it. Dr. Harrington, who has known you for 6 years, said to take whatever time you needed and then gave you the extra shift when you asked. In the same conversation, because both things can be true, $34,000 is now closer to $43,000. It doesn't fully close the gap, but it keeps you from choosing between the storage unit and Claire's school supplies. The life insurance check arrived at week 10, $150,000. You have it in a savings account. You have not touched it. Not because you are being disciplined, because touching it feels like the last wall coming down, and you are not ready for that yet. Reyes called to follow up on whether you wanted to pursue the estate challenge. You told her you were still deciding. You are not still deciding. You have decided. But saying so out loud means saying out loud what it cost you to decide it, which is that you cannot afford to spend $30,000 to $50,000 fighting a legal battle that might take 2 years to resolve and might not change anything. You cannot do that to Claire. You cannot do it to the $150,000 which has to last until she is grown. The legal challenge dies the way most things die in this situation. Not with a decision, with a non-renewal, with a call that doesn't get returned. Your sister-in-law, Patricia, Marcus's younger sister, reached out 6 weeks after the move. She sent a text. It said, "I know what they did wasn't right. I'm so sorry. I don't know what to say. I'm sorry." You read it and set the phone down and didn't respond for 2 days. When you did respond, you said, "Thank you." That was all. There wasn't more. She texted again. "I'll call when the dust settles. I want to see Claire." You said, "Okay." She hasn't called. The dust apparently has not settled. Deborah still comes over. She is the one constant. She shows up with food and sits in the kitchen of the new apartment and doesn't say anything about how it compares to the old one, because Deborah is a person who understands that comparison is cruelty in a moment like this. She brings her daughter, who is 8, and the girls go into Claire's room and close the door, and you can hear them through the wall, and that sound, the ordinary sound of 2 children playing, is the most normal thing in your life for approximately 45 minutes, and then it stops. This is where things actually are. It has been 7 months since the parking garage, since 2/17 on a Tuesday. The house sold. You don't know the price. You didn't ask. It didn't belong to you by the time it sold, and asking felt like pressing on something that had already finished hurting. The probate case, 2024 PR 7841, was closed 3 months ago. Estate administered. Assets distributed per the terms of the 2024 document. You work 4 days a week. You make $43,000 a year. You live in a 2-bedroom apartment on Oakland Park Avenue. Your rent is $1,750 a month. You are covering it. Barely is a word you'd use, except barely has started to feel like its own kind of stable, like a low hum that you can live inside. Claire is in 2nd grade. She goes to the same school, same teacher. You made sure of that. It was the one thing in the 60-day scramble that you managed to protect without anyone contesting it. She does not have a piano. The piano went back with the piano, picked up on a Saturday while you were at work because you asked Deborah to be there instead of you, because watching it leave was not something you needed to do. She's on a wait list for a piano at the community music school on Indianola. The wait list is 8 months. You are at month 4. The $150,000 is in the account. You have not touched it. You do not know yet what you'll use it for. A house again, maybe. Eventually. A down payment. The math is different now that you're doing it alone, but the math exists. And as long as the math exists, you can work with it. Marcus's height is still on the doorframe at the house on Britten Road. You measured him there once, standing back to back with Claire, and he was exactly 12 inches taller, and he made a joke about it that was not funny, and you laughed anyway. You don't know if whoever owns it now painted over it or left it there. You don't know. You won't know. The doorframe belongs to someone else. You close the folder with the probate number on the tab and put it in the filing cabinet in the bedroom closet. The folder is still there. Next week, POV, you're fired on maternity leave. The lawyer says it's not worth pursuing. If you want to be there when it drops, subscribe now. The link is below.